And we are back. Welcome to my channel, Get Legit LLC. And today we'll be having a rather really legal discussion decision. And I want to do an additional disclaimer. I normally have my disclaimer under the Fair Use Act, but today for this discussion, I want to do not a disclaimer actually, which says that the video is our analysis. It is not a legal opinion. It is not legal advice. It is not intended to offend anyone. This is Get Legit LLC's opinion after having reviewed the relevant laws and cases in the state of Missouri, having regard to the facts as presented and as presented in television interviews, as well as what we were able to read from the cause form, the police cause form, okay? And we're just going to put it out there. What is our position when it comes to whether or not Andrew Lester has a legal defense for shooting Ralph Yarl? As usual, this is our disclaimer. Materials being used, any copyrighted material that is being used under the Fair Use Act. And if any persons out there believe we went beyond the Fair Use Act, please get in touch with us. Our email address is there, getlegit2022@gmail.com. Please, my channel is growing, and I must say I'm very, very proud. I think we have 252 strong subscribers. Thank you all. Thank you. But for those of you who haven't yet subscribed and would watch the videos and like it, please do subscribe. Help a girl out. Subscribe, like, comment, and share. So now let's get into it. I entitled this video "The Ugly Face of Racism." And I want to quote Lee Merritt here. He is the attorney for the Yarl's family. And he said, "Too often in America, his skin alone is his weapon. It's the weaponization of Blackness itself." And I must say, when I listened to the television interviews and I watched on social media what had happened, it's like you're in a position where you're saying, "Man, look at this," compared to Emmett Till, where that wasn't the case, where the outrage from the Black community wasn't the forefront of the discussion. And now we have here a minor who was shot, and the outrage, the pouring from celebrities, the pouring from everyone. And that was enough to lead to some change, to Andrew Lester being charged. I do know in Emmett Till's case, there was a trial, but no conviction. Well, they were found not guilty. And there was later a story in the news, in the magazine, where they actually, confessed. But that was it. And it's interesting to know that the woman who made the complaint, who initiated everything, is still alive. But here we are, 2023, a case where a minor was shot. And so I entitled this video "The Ugly Face of Racism." And it's not talking about the outer face, but it's that inner face. An inner face of racism where people just hate you because of how you look, where people can't get past the past, where people seem to think that we're supposed to go back to a day and age where you're supposed to walk with your head down and be quiet and not say anything and be subservient, be less than, be treated as less than, and accept that you're less than. Come on. Anyway, let's have this discussion. This gentleman, this elderly white gentleman, name is Andrew Lester. He's accused of assault in the first degree and armed criminal action. This case emanates from Missouri, for those of you who, for whatever reason, may not know. So you might be asking, well, what is assault in Missouri? Assault, first degree, it says a person commits the offense of assault in the first degree if he or she attempts to kill or knowingly causes or attempts to cause serious physical injury to another person. And then it goes on to the second, subsection 2. Says the offense of assault in the first degree is a class B felony unless the course thereof the person inflicts serious physical injury on the victim, or if the victim of such assault is a special victim, as the term special victim is defined under section 565002, in which case it is a class A felony. And I must state that in this case, they have charged him for first degree assault and categorize it as a class A felony. And it says here that knowingly cause serious physical injury. It is a class A felony for under which he is charged. And apparently from here what I got, it says 85% of this sentence must be served before he's eligible for parole. And so what constitutes first degree assault? You might be asking, just to summarize. First degree assaults happen in Missouri when a person intentionally tries to kill or intentionally causes or tries to cause a serious physical injury to someone else. And first degree assault is usually a class B, but it is a class A felony if the target is a special victim. So you might be asking, okay, what is a special victim, or who would be a special victim? So it says here, law enforcement officer assaulted in the performance of his or her official duties or as a direct result of such official duties. Emergency personnel and any paid or volunteer firefighter, emergency room hospital, or trauma center personnel or emergency medical technician assaulted in the performance of his or her official duties or as a direct result of such official duties. A probation and parole officer assaulted in the performance of his or her official duties or as a direct result of his or her official duties. An elderly person, a person with disability, a vulnerable person. So while I wasn't able to find a definition of who a vulnerable person is, I would like to think that a minor, which Yarl falls in that category, would be a vulnerable person, which is why it is a class A. And then it goes on to say any jailer or correction officer, a highway worker in a construction or work zone, as the term highway worker is defined as, any utility worker, meaning any employee of a utility that provides gas, heat, electricity, water, steam, telecommunication services, any cable worker, any employee of a mass transit. So the only one category here that I would say Yarl falls under would be a vulnerable person, and that being by virtue of his age. Moving along. Why not charge for hate crime? And I know in the media there has been this talk and this call for, well, hate crime, because you know what it emanated from. And it says here, Missouri law, prosecutors can add hate crime charges to felonies that are knowingly motivated because of the victim's race, color, religion, national origin, sex, sexual orientation, or disability. He said, and the prosecutor, Zachary Thompson, said at this point, you were talking about double jeopardy issues. And for those of you might be by asking, well, what they mean by talking about double jeopardy issues. Well, double jeopardy. Double jeopardy is a Fifth Amendment protection clause, and it protects against 3 abuses. Now let's get into the abuses. One, a second prosecution for the same offense after you're acquitted. So you have a trial, you've been found not guilty, but then they want to charge you for that same offense for which you were acquitted. That's a double jeopardy case. A second prosecution for the same offense after conviction. So you've had a trial and you were found guilty, but for whatever reason, based on the same facts, they want to try you again. That is double jeopardy. Ugh. And a third one being multiple punishments for the same offense. Now, to my mind, given what he has said, I believe it is this third category within which the prosecutor is looking at. Multiple punishments for same offense. And when I did a quick research to see what's the case in Missouri when it comes to multiple offenses, punishment, they go back to as far as I was able to research, 1980. There was a case, Sowers and the State. And in that case, this person held up a fast food store. He pled guilty to first-degree armed robbery and using a firearm to commit a felony. And the judge sentenced him to 5 years for the robbery and 3 years for the armed criminal action. So that matter was appealed. And it went to Missouri Supreme Court, and the Missouri Supreme Court held that the sentencing for the armed criminal action violated double jeopardy clause, since both offenses arose out of the same set of circumstances or the same facts. And that case saw a back and forth between the Missouri Supreme Court and the United States Supreme Court. There was a back and forth, almost like they were playing ping pong with the decision. And so it reached a point where in the case of Missouri and Hunter, Chief Justice Berger, he set the record straight. And he said basically the Missouri Supreme Court misread their judgments when it comes to double jeopardy. And so, it's interesting to see that this same case now is in Missouri. And I could appreciate why they would not bring a charge for hate crime and cite the double jeopardy rule. So we just got to see. And if you guys want me to do a further research into double jeopardy and what that has to do when it comes to the multiple punishments, I can do that. I already downloaded a lot of information that I'm reading up on it, a lot of information from different universities. And so, if you want me to get into that to explain what it is, then yeah, I can do that. I can definitely do that. So you could get an appreciation as to why they are hesitant to bring a hate crime charge, because what it can do if Mr. Lester is convicted, and that's if he's convicted and sentenced, they could then raise the issue of double jeopardy, having regard to all these charges would have emanated from one transaction, one conduct, one offense. Okay. Now, I want to get into this here because when I get into the facts and I start to explain what Lester said happened as opposed to what Yarl said happened, it raises some issues. And so I want to read from the State and Wayland, which explains the person's action in terms of Lester. Lester said he opened the glass door and then he saw this black person, 6 feet tall, approximately, keyword, approximately 6 feet tall, and he opened fire because he thought the person wanted to come into his house. However, it says here, first degree assault. Now we're talking about the offenses for which he was charged. He's charged with 2 offenses. 1, first degree assault, and 2, armed criminal action. So first degree assault, what the court will be looking at when they look at that particular offense. It says here, a defendant has to act purposefully as to the person defendant is charged with assaulting. This is because first-degree assault requires a jury to find that the defendant, in this case Lester, attempted to kill or to cause serious physical injury to another person, which requires proof of a very specific intent on the part of the actor to accomplish that objective. So what it is saying is Lester would have to intend to cause death or serious physical injury to whomever he was shooting at. And I believe that would have been the case, given what he said to the police, that, he felt as though someone was trying to come into his home, and so he fired 2 shots immediately upon opening the door. It goes on to say, it makes reference to a case, State and Gonzalez, and then it goes on to state, The incoherent crime requires, and incoherent means the internal, the mind. Incoherent crime requires a firm purpose and is limited to purposive conduct or specific intent to commit the crime allegedly attempted. In analyzing the mens rea requirement for first-degree assault, this court emphasized in Wayland that while a defendant needn't know the name of the person he assaulted or to have specifically decided to injure each person who was injured or threatened with injury, a defendant may only be guilty of first-degree assault as to the person whom the defendant was aware were present when he engaged in his criminal conduct. And so Lester said he opened his door. He saw this tall, almost 6 feet person there, and he felt as though this person was about to come into his home because they had their hands on the storm door handle, and he fired a shot. So he intended to shoot whomever that person was. And the law is saying, you don't need to know that person's name. The same way the law, I would say, is suggesting that you wouldn't have to know that person's age. And I think that is key. So he intended to shoot whomever that person was that he saw in front of the home because he believed in his mind, he believed, it's very subjective, that this person was about to enter his home. And as he told police, quote unquote, he was scared to death. So while we're emotional about this case, I think there is a point where we need to be realistic and we need to look at the elements and need to look at the circumstances that transpired in this case as well. Second one, armed criminal action. Armed criminal action, it says, any person who commits any felony under the laws of this state by, with, or through the use, assistance, or aid of a dangerous instrument or deadly weapon is also guilty of the offense of armed criminal action, and upon conviction shall be punished by imprisonment by the Department of Corrections for a term of not less than 3 years and not to exceed 15 years, unless the person is unlawfully possessing a firearm, in which case a term of imprisonment shall be for a term of not less than 5 years. The punishment imposed pursuant to this subsection shall be in addition to and consecutive to any punishment provided by law for the crime committed by, with, or through the use, assistance, or aid of a dangerous instrument or deadly weapon. And it goes on to say, no person convicted under this subsection shall be eligible for parole, probation, conditional release, or suspended imposition or execution of sentence for a period of 3 calendar years. So the least a person would have to serve is 3 years before any of these conditional release can be considered. So what this is saying is that we will all agree a firearm is a deadly weapon, so that's out. And we will agree that if the person is convicted, the minimum years, it starts at 3 years, it does not exceed 15 years. And unlawfully possessing the firearm, we don't know. There isn't anything in the media, anything in the statement to suggest that the firearm within that Mr. Lester used to shoot Ralph Yarl, that it was illegal. If it was illegal, this is saying that the minimum mandatory years starts to run from 5 years. If it was legal, a firearm means he has a license for it, then it starts to run at 3 years. I want to explain, when we say consecutive sentence here, it means that if Lester is convicted, he will have to serve the sentence for the first degree assault first, and then the sentence for the criminal armed criminal action will run after he would have served that first sentence for the assault. So let's say he's sentenced to 4 years for the assault. He will have to serve that 4 years first, and let's say he's sentenced to 6 years for the armed criminal action. So that 4 years will serve first, and when he finished serving that, then he starts to serve the additional years for the armed criminal action. So when you see the word consecutive, that is what that means. If you see the word concurrent, concurrent means both of them running together. So let's say he gets 4 and 6 years. Then concurrent means while he's serving that 6 years, that 4 years is running as well. So he only serves 6. It won't be 6 plus 4, which gives you 10. For this offense, it's consecutive, which means if he gets 4 and 6, then that means it is 10 years. If it's concurrent and he gets 4 and 6, that means it's only 6 years, because the 4 years would be consumed by the 6 years, which is the majority. So it goes on to explain if the person is charged for a second and a third offense, what the sentencing range would be. But we don't have that information. There is nothing to suggest that he has been convicted of a previous offense of armed criminal action or the felony. So armed criminal action. So we don't have that. So while I have the information here for education purposes, you can look at it, read it, and see what you make of what you may of it. But given the circumstances that we've been shared to us, we don't have that to say that this is a second offense for which Mr. Yester has been charged for armed criminal action. It could be, and if that is the case, then these will come into effect. So again, just to summarize, if you're convicted, you face a mandatory minimum of 3 years sentence for armed criminal action and a maximum sentence of up to 15 years. However, if you commit the crime with an illegally possessed firearm, you face a mandatory time minimum of 5 years imprisonment. And the punishment for armed criminal action is in addition to the sentence received for the original crime. And in this case, the original crime is a first-degree assault. And if convicted, you are not eligible for parole, probation, conditional release, etc. for at least 3 years. You also must serve your prison sentences consecutively, as I explained earlier what consecutively means. So again, we do a summary if there is a second and a third offense. Let's say Mr. Lester was charged and convicted prior to armed criminal offense in the past, and this is his second, then these things will apply. So, as we all know, people were frustrated. Frustration grew after a minor was shot in his head and the right arm, and after ringing a doorbell of a white man. The police detained the white man for 2 hours and released him. This is despite Missouri having a 24 hours holding, which means they could have held him for up to 24 hours, but for whatever reason, they chose 2 hours. So it seems to everyone was like, it seemed as though the Missouri law enforcement was going to deny Ralph Yarl due process. And so people power changed that. People power and the celebrities and just the outpour in the media. Everybody played a role to ensure that something was done, that this just, a situation was swept under the rug. And so then you had it where Ralph Yarl Andrew Lester was charged. And so, but in any case, you have to ask the question, what do you want? Do you want just to have someone charged, or do you want someone to be convicted? Well, if you want a conviction, like I believe most people would want a conviction, we need to look to see, are there any defenses at Lester's disposal? Let's look. So, in Missouri, there is a use of force in defense of person. And that is a code. You can see it, you can research it, go online and find it and read it. But I have it here. See, Get Legit is helping you guys out. So it says a person may, subject to the provisions of subsection 2 of this section, use physical force upon another person when and to the extent he or she reasonably believes such force to be necessary to defend himself or herself or a third person from what he or she reasonably believes to be the use or imminent use of unlawful force by such other person. So right off the cuff, what this is basically telling you that is it's subjective. The subjectivity of this legislation. It's not what we know or what we see or what we think. It's subjective to what the individual thinks at the time. And if that thinking is reasonable. So Lester said to the police, he opened the door. He saw this tall black guy person standing there. He believed that person was about to come into his home. And so he acted, and he was scared to death. And so he acted. So it's what the individual, the defendant, how that person felt, how that person, took whatever he saw and whatever he believed. Let's go to the second part. Remember here it said subject to subsection 2. Well, let's read what subsection 2 is saying. Subsection 2 is saying such force is used against a person who unlawfully enters, remains after unlawfully entering, or attempts to unlawfully enter a dwelling, residence, or vehicle lawfully occupied by such person. Let's look at that. So it could be that you could use a force if somebody enter your house, and when they enter, they remain there, unlawfully remaining there after entering, or they attempt to unlawfully enter. So the issue here, he said, when he opened the door, he saw this 6 feet, almost 6 feet person, black man, pulling on the handle of the storm door. So does that mean that Ralph Yarl was attempting to unlawfully enter a dwelling, his dwelling? How would it be an unlawful entrance if there is no invitation? If there is, let's say there was a sign that says no trespassing, but from the facts we don't get that. But there's a doorbell, which kind of suggests that you could ring the doorbell. You're welcome to enter on my property and ring that doorbell. But let's say Ralph was standing there and he told him, "Get off my property, get out," and he decided to like wait there because he's waiting for his brothers. It's a different situation. But for the purpose of this legislation, it says attempts to unlawfully enter a dwelling. And so we haven't gotten anything from Lester to say he invited Ralph inside. All we got Lester saying is that he opened his glass door. He saw this person, almost 6 feet tall, this black person, and the person was holding on to the handle of the storm door. But as usual in most trials, you're going to have conflicting. Ralph is not saying that. Ralph is saying he just rang the doorbell. And the person inside took a lot of time. And then eventually he opened the door. And as he opened the door, he had a firearm and he shot him. So it will be for the court to make that determination, the jury. So it goes, these slides continue to explain what it is, what it's talking about when it comes to the use of force. So I want to go through what was said in the media as opposed to what was said in the police cause statement form, so that you could have an appreciation of some of the things that were said. So Lee Merritt, who is the attorney for the Yarl's family, he said Ralph left home about 9:30, between 9:30 and 9:45, and that is at night. And I think the fact that it was at night plays a crucial role as well. Well, not I think, but it plays a crucial role as well. He said, Andrew Lester, let's look at the surrounding circumstances, all right? Andrew Lester lives in a predominantly white neighborhood that is referred to as, quote unquote, God's country. And he said God's country is a title that's supposed to reflect conservative and a heavy law enforcement presence and having to do with the housing and the living in the area. He said he has received reports from Blacks who visited and who live there, including Ralph's family. They say that there is a standing hostility towards Black presence. So his attorney said that Ralph rang the doorbell and said whomever was inside took long to respond, that he heard rustling and then the door opened and he was confronted by a man who said, "Do not come back around here," and shot him, and he fell down and the person shot him a second time. The attorney then said Ralph ran and banged on 2 doors and no one answered. He then banged on a 3rd door and a neighbor told him to put his hands up, put his hands in the air, lie on the ground, and Ralph complied. So I want to preface what Lee Merritt said when it comes to when he went to the 3rd neighbor's house to what was said on CBS Morning News by our person, Zach Doval. Zach Doval did an interview and he said he heard a banging and he called 911. He said the operator told him that there is a report of a shooting in the area and that he should not open the door. Okay. Remember what Ralph's family attorney said. He said he banged on the 3rd door and a neighbor told him to put his hands in the air and to lie on the ground, which Ralph did. So it would seem to suggest that Doval, despite the 911 operator telling him not to open the door, it would seem as though he later did open the door to render aid. CNN News, they also gave a interview in which they said that they spoke to a neighbor who said that she did not hear the gunshot. She did not hear the gunshot. She did not hear the gunshot. What am I saying? Did not hear. Did not hear. Did not hear the gunshots because she was asleep. So that tells you something of the neighborhood, the timing of when this incident happened. I believe Lester said he was about to go to bed. So all those things, the circumstances when the shooting took place, is going to play a role, as opposed if the shooting had taken place, let's say 4 in the afternoon. Okay. So I'm telling you directly from the police cause statement form what Ralph said and what Lester said. So Ralph told the police he was told by his mother to pick up his brothers. The actual address where his brothers were at was in 1100 Northeast 1115th Terrace, Kansas City, Clayton, Missouri, Clayton County, Missouri. He said he parked in the driveway and walked up to the front door. The mail inside took a long time. That should be not two. Took a long time, but finally he opened the door holding a firearm. He said the man immediately shot him in the head and he fell to the ground. And while on the ground, he was shot a second time in the arm. He did not pull the door. He said he did not pull the door and that this was the first time coming to the residence. He said he ran away to keep from being shot at. And Lester told him, "Don't come around here." He said he went to multiple residences for assistance, telling them to call the police. Now, what did Lester say to the police? Lester told the police that he gave, first of all, he gave written consent for them to search his residence, which shows that he cooperated with the police. He told the police he lives alone, which goes to the argument as to why he said he felt scared for his life and why he probably would have acted the way he did. He told the police he has an interior door and a stone door. He opened the interior door and saw a black male approximately 6 feet tall pulling on the exterior door handle. He said he believed someone was attempting to break into his house. He stated no words were exchanged during the incident, and I think it's key. Ralph's attorney and Ralph, they said that he told him not to come back around here. And if you watch the timing when Ralph said that was said to him, he said he ran away to keep from being shot. So it was after him being shot, he ran away, and that's when he said Lester told him, "Don't come around here." So it seems to suggest that while he was running, that's when Lester said, "Don't come around here again." And Lester did say that there wasn't any exchange during the incident. He didn't say there wasn't an exchange after, but he said, and an exchange would mean I say something to you, you say something back to me. All right, so we need to look at these things very carefully. He said the male ran away and he immediately used his home phone to call 911. So here again, we see Lester doing what I believe all citizens should be doing. He did an act, he shot someone, but he called 911. And he stated he observed a vehicle in the driveway, which he believed first belonged to a male person, but he didn't see anyone else in or around the vehicle. He said that it was the last thing he wanted to do, but he was scared to death. It would be an interesting case for 2 reasons. One, because a case where you have 2 vulnerable persons, an elderly person and a minor, and the perception of the elderly person having regard to all his faculties, having regard to all whatever is happening with him, his circumstances. And then you're going to look at that as to a minor. And the first thing, and remember the legislation said it doesn't have any regard, you don't need to know the person's name. And I would insert, you don't need to know the person's age. What if Ralph was not a minor? It's something to think about. In that moment, if Lester is saying, I felt threatened, I felt scared to death, I felt this person was attempting to come into my home. It's at night. Bear in mind, it's at night. Said he was about to go to bed. What would you do? Think about it. And we already know they backdrop to this neighborhood, predominantly white. Call themselves the neighborhood God's country. Conservative. Doesn't mean it's right? No. But you have to look at it in perspective of the surrounding circumstances, because that will be what the court will have before it. So now I want to go through a judgment that came right out of Missouri court, because this incident didn't happen in Missouri, and so you want to get an appreciation of, does Lester has any, if he has a defense, Is there any defense available to him in his circumstances and in regards to what happened? And so to this, we're going to talk about what we call is castle doctrine. It comes from the statement where we say a man's home is his castle. And so let's get into it. So, excuse me. Under Missouri law, there is a statutory right of self-defense which allows a person to use physical force upon another person when and to the extent he or she reasonably believes such force to be necessary to defend himself or herself from what he or she reasonably believes to be the use of imminent or unlawful force by such other person. This general right to self-defense also permits a person to use deadly force if he or she reasonably believes that such deadly force is necessary to protect himself or herself or her unborn child or any other against death, serious physical injury, or forcible felony. Bear in mind, Lester Yarl, this is almost minutes 10 in at night. He's about to go to bed. He told the police he lives alone. He's an elderly person. He said he was scared to death. He said he felt the person was about to come into his home, attempted to come into his house. So all those things you need to look at when you're determining whether or not, or he said the person is approximately 6 feet tall and of course black. So look at those things carefully. So it says here, Missouri law recognizes what is commonly known as the castle doctrine, codified in section, and it lists this section, and it says, under the castle doctrine, a person need not face death, serious physical injury, or any forcible felony to respond with deadly force. Rather, Missouri's castle doctrine provides that a person is justified in using deadly force to defend himself or herself or a third person from what he or she reasonably believes to be the use of imminent use of unlawful force by such other person, and such force is used against a person who unlawfully enters, remains after unlawfully entering, or attempts to unlawfully enter a dwelling. So you need to look at those words carefully, and we need to look at it to see possible defenses for Yarl. And look at the wording. It's not that you have to already be in the home. You could be attempting to get in the home. And it's subjective test. What he reasonably believed to be happening. And the court, more than likely, will definitely look at the time of the night, the age of the individual, his fear that he had, the fact that he lived alone. I think even a neighbor that they interviewed a neighbor in the police cars, the neighbor said she saw the vehicle drove up and she found it strange that this elderly person was getting visitors late at night, that time of the night. So we can't be emotional about it and not be realistic and look at the possible defenses and see whether or not Andrew does have has a defense. It may not be for the second, but it could be for the first. But what we don't have, and I think would be crucial, is when the kind of firearm that he used, when you fire that, if there is that quick release or whatever you call it, I don't know those terms, but I am sure they will have firearm expert to speak as it relates to that, the first shot, the second shot, because you could argue the first shot, okay, it could be that he's protecting his home, he's justified. But the second shot, why a second shot? So you would need to get into his head why you fired a second time. Remember, he probably didn't know he shot the person in the head. We don't know, but we have to wait and see until the trial, all right? So let me go further into the castle doctrine. It says the castle doctrine, as set out in section 563.031.2, subsection 2, incorporates the requirements of the general statutory right of self-defense in section 563.031.1 and requires a reasonable belief in the use of actual or imminent unlawful force by another to justify deadly force. And then it goes on to make reference to a case, but I want to go to the highlighted section here that says, finding the unlawful occupier of a dwelling, residence, or vehicle, or an owner or lessee of private property is entitled to use deadly force to repel an unlawful entry but only if he meets the requirements of self-defense set out in Section 563.031.1. So you first need to satisfy self-defense for you to then go on to use the Castle Doctrine. So I want to go through a case, and I believe this is a leading case in Missouri having to do with the Castle Doctrine. So I'll be reading here, guys. It says, during the trial, evidence established Ward loaned Strother the use of his vehicle, and at the time of the shooting, Strother was behind the wheel of Ward's vehicle with his permission and at his request. Neither party disputes Strother lawfully occupied the vehicle as required by Section 563. Remember, you could be in defense of your home. It could be a vehicle. And so in this case, it was a vehicle. The girl was sitting in the vehicle and the other girl came up to her and hit her. In order for her to hit her, her hand had to go through the window and hit her. And there was a firearm nearby, and she grabbed the firearm and she shot. So that's what this case was looking at, to determine whether or not she can use this Castle Doctrine. She was in a car, the hand went through the window, hit her, so that's what this court looked at. The court said there was substantial evidence presented that Strother reasonably believed force was necessary to defend herself from what she reasonably believed was the use of imminent use of unlawful force. So that's another thing the court will be looking at in this case with Lester and Ralph Yarl. And the court went on to, there was a denial of the Castle Doctrine to the jury. They never gave that. And so I want to read what I have here highlighted, where it says, under the general self-defense instruction given to the jury, Strother was justified in using deadly force only if she reasonably believed, again, subjective test, reasonably believed she was protecting herself against death or serious physical injury. And it makes reference to the section. It says, under the Castle Doctrine, however, Strother did not need to face death or serious physical injury to respond with deadly force. Rather, as long as she met the other requirements set forth in section, and that's the self-defense section, Strother needed only to reasonably believe force was necessary to defend against the use of imminent or unlawful force by another. So this case will definitely be a case that will be looked at in the Lester case, okay, to see whether or not he reasonably believed that he had to use that force. Here we have what the court said, when there is evidence supporting more than one claim of justifiable use of physical force, such as evidence supporting both self-defense and the use of deadly force by a person unlawfully in the dwelling or vehicle, a separate numbered cross-reference paragraph for each instruction on the justifiable use of physical force will be included in the verdict director. So it's just saying that the trial court should have made a Castle Doctrine summation to the jury, which she didn't, but they said he should have done so because she would have the girls in the car would have had a reasonable belief that she needed to use force, given the fact that the girl went up to her, put her hand through the glass of the window and slapped her. Remember, it doesn't just, the Castle Doctrine doesn't just apply to your home, it also applies to your vehicle. So here we have a picture of persons who were demonstrating, and rightfully so, demonstrating for Ralph to Lester to be brought to account. And I have here several, statements that were made by the various attorneys. And one discussion that they had was the issue as it relates to stand your ground. Stand your ground applies. It's a situation where the Castle Doctrine says that you can use lethal force when you're inside your home. Stand your ground takes it outside of your home. It takes away that added defense to show that you retreated. So stand your ground, it's saying basically you don't need to retreat, all right? And you don't need to just be in your home. And so that is it. I just wanted you all to look at those circumstances, look at what the jury will more than likely be looking at in this case. It's not to say one way or the other how we believe it will go, and it's not for us to be emotional on the issue, but it's for us to be, to just be vigilant and to look at these things. I want to do upcoming videos as it relates to the cheerleader who was shot and the New York woman who was killed, and in North Carolina, the neighbor who shot after a 6-year-old. after a basketball rolled onto his property. For whatever reason, these people are wilding out. They feel as though having a firearm to just deal with every situation is the way to go. For they forgot, to be neighborly, to be neighbors. And my thing to us, let's be good neighbors. Let's be respectful of each other's humanity, and remember that that person might not look like us, might not act like us, might not walk like us, talk like us, but they are a human being. And for us to be mindful of that. Of course, you protect yourself, but be mindful. Be mindful. I believe in the Ralph Yarl's case, perhaps Mr. Leslie, if he was so fearful, should have called 911 before he opened the door and shoot. Should have called 911, and since this area is predominantly police, why didn't you call the police before you came out and shoot someone's child? So let that be a lesson to all of us. If you feel threatened, you feel fearful, call the police first. Let's try that road. Call the police, have them come and ask the person, what are you doing here? And then this could have been, gone a different way. And a family would not have had to be on that fear that they would be losing their child. It's a sad situation both ways, but it goes to show the ugly face of racism. When all you see is a black man, and that justified the need for taking that kind of that you took. And so, I want to end and say, I hope Ralph Yarl do a wonderful recovery. I hope he recovers. I hope he overcome the ordeal, the tragic ordeal. I hope he overcome the psychiatric impact it could have on him, and probably does have on him. So let's just all be mindful that we live in a world. We have to be humans. We can't walk around and have our hate in our heart, because it's going to loom its ugly face. Okay? For those of you who haven't done so, please like, comment, share, and do subscribe. I'm looking at another video that I want to work on as it relates to the U.S. Supreme Court when it comes to the abortion pill case. I want to look at that. I want to do a review on that. And so I'm working on those different videos. But again, Get Legit, LLC, come to you. We explain some legal issues so that we could all be mindful of what is happening. We could all be mindful of how it is that we can go about learning the law and appreciating the law when it comes to these legal topics. Until next time, I say thank you and